Sorry, everyone. Sharon's just started to record the seminar, which is great. So welcome those who are watching after the event as well. I'm just looking up the Children and Families Act using my browser, and we'll see that what you're looking for is the legislation.gov.uk website, because that's the official text of the law. And so, for example, we have Part 3 of the Children and Families Act, children and young people in England with special educational needs or disabilities. But I'm going to suggest that the Children and Families Act is really, Part 3 at least, is really an education act with health and social care bolted on. And the core duties in relation to disabled children and young people are not found in here in terms of social care, at least. They're found elsewhere. So the starting point for which is the Children Act 1989. That's where we're going to go to start this tour. The Children Act 1989 was a huge landmark piece of legislation which created the modern social welfare system for children, and includes, of course, very significant provisions in relation to child protection. But within Part 3, again, of the Act, Children and Families Act and Children Act, Part 3 we're concerned with, there is a series of duties that require support for children and families provided by local authorities in England. And we see at the beginning of that, Section 17, which is about children in need. And one of the most fundamental points I'm going to be making this morning is that every disabled child is a child in need. So I'll explain how that works in just a moment. We see under Section 17, subsection 1, says it shall be the general duty of every local authority to safeguard and promote the welfare of children within their area who are in need, and, so far as consistent with that duty, to promote the upbringing of such children by their families by, so they've got to try and achieve these goals by doing something, which is providing a range and level of services appropriate, to those children's needs. So that begs the question, well, do we have to provide as a local authority a service to any particular child in need? And that question went to the House of Lords back in the 1990s, the former Supreme Court, and their lordship said no. Their lordship said that there is not a duty under Section 17(1) to provide a service to any particular child in need. In that case is known as G and Barnett. Instead, it's a general duty, as the name suggests, to have this range and level of services available in every area. But their lordship said in G and Barnett that local authorities must assess every child who is, or I would suggest who may be, a child in need, because until they've done an assessment, they can't work out whether or not they should provide them with any services within the range and level that are available in the area. So the outcome of the G and Barnett case was that there isn't a duty to provide services under Section 17 of the Children Act 1989, but there is a duty to assess, even though those words aren't used here in Section 17. We'll see where something closer to an assessment duty comes later in the Act. So other points to identify in Section 17. First of all, under Section 17(3), services can be provided to any family member of a child in need if it's provided with a view to safeguarding or promoting the child's welfare. So services can be provided, as you'd expect, holistically to families. We also see that under 17(4)(a), before deciding what, if any, services to provide for a particular child in need, the local authority shall, so far as reasonably practicable and consistent with the child's welfare, ascertain the child's wishes and feelings. So there's a duty within the assessment process to understand what the child wants and give due consideration to those wishes and feelings before they make a decision as to what, if any, services to provide for a particular child in need. We know that under Section 17(6), accommodation can be provided. So that's one of the ways in which disabled children can receive, quotes, respite care away from the home, but also families could be accommodated together, perhaps for a holiday, for example. We'll see a bit more about that in a moment. And it is possible for local authorities to charge for services under Section 17, but very few do. So I'm not going to spend any time on that unless anyone has any specific charging questions. Now, why did I say earlier that every disabled child is a child in need? Because that's what Section 17, subsection 10(3) says, 10C, sorry, says. So for the purpose of this part, a child should be taken to be in need if C, he is disabled. And what's really interesting, I think, about that language is we see that the other definitions in A and B are much longer and are about a relative level of difficulty the child and family are facing. So you're a child in need if you're unlikely, which shows there's a judgment to be made, to achieve or maintain a reasonable standard of health or development without the provision of services by the local authority. So if the local authority think that without doing something, you're unlikely to thrive, essentially, then you are a child in need. They must assess and they may provide services. Or that your health or development is likely, again, judgment, to be significantly impaired or further impaired. But for the category of disabled children in need, there's no judgment. It's just a matter of fact. For the purposes of this part, a child should be taken to be in need if they are disabled. And then we have a definition in 1711 of what a disabled child in need is. A child is disabled if they are blind, deaf, or dumb, very out-of-date language, of course, or suffers from mental disorder of any kind. So if you have any kind of mental disorder, then you are automatically disabled for the purposes of section 17 and therefore a child in need. Or if you're substantially and permanently handicapped, again, old-fashioned language, by illness, injury, or congenital deformity. So it's a very broad definition and does include any child with any recognized mental disorder, or indeed a child where it's accepted that they have a mental disorder, but it may not be diagnosed in precise terms. So it's very unusual that there will be a child whose parents consider that they are disabled, who is not in fact disabled for the purposes of the Children Act 1989. So that's a whistle-stop tour through section 17. I'll stop there to see if there are any specific questions on these points at the moment. So one of the questions is, does this legislation cover children up to 18? And the answer is yes. So the Children Act 1989, section 17 at least, concerns children who are those up to the age of 18. There are transition provisions, which we'll look at in a moment. But the main social care obligations in relation to those aged 18 or over is in the Care Act from 2014. And we'll look at that later on. So that picks up a couple of the questions. Can social care provide housing? Yes, we've just seen that under section 17, subsection 6. But generally, they won't need to do so because housing is normally provided by the housing authority, which of course in unitary authorities, cities, for example, will be the same body, but the housing will be provided under the Housing Act instead. So very rare that section 17 is required to provide actual accommodation for families of disabled children, unless the family have no immigration status and therefore are not eligible for Housing Act accommodation. So that's the main exception to what I've just said. So the question here is section 17 a duty to children only or to children and families? Well, as I've said, you can provide services to the family of children in need under section 17, but the focus of section 17 is on the child in need. There are other provisions, as we're going to see in a moment, for carers assessments, for parent carers of disabled children, and also for siblings as well. But the core focus of section 17 is on the child. Does ASD or ADHD count as disabled? What about functional neurological disorder? Well, yes, because those are all mental disorders of any kind. So every child who's diagnosed with ASD or ADHD is a disabled child. And a child with functional neurological disorder, I assume that is a mental disorder, recognized mental disorder, that would clearly also fall within the definition as well. What about if a local authority refuses to assess? So an excellent question. You will be aware, I'm sure, many of you, that the rights of appeal to the tribunal, Sendist, are limited to issues in relation to EHC plans. And so there isn't a right to appeal to the tribunal in relation to a decision by a local authority not to carry out an assessment. And therefore you have two options as a family. One is the complaints process, so the local authority complaints process under the Children Act, which ultimately goes up to the local government and social care ombudsman. Now that's, I would suggest, the appropriate route to follow if you've got a relatively low level dispute, or if you've got something that's gone wrong in the past. But if you've got something that's serious and urgent, or where there's a genuine legal issue, so for example, the local authority is saying we don't assess children with certain conditions, and you say, well, that's unlawful, then the remedy will be judicial review. And judicial review is a process, as people may well be aware, in the High Court, which I've written about on my blog. So I'm going to take us there briefly. I'll put the link in the chat. Where the High Court judge reviews the lawfulness of policies or actions, decisions of public bodies. So it's not a tribunal which looks at the merits of the case. It's a much more formal legal process looking at whether or not the local authority has made a lawful decision. Now, how do you bring a judicial review? Well, the first point is you will definitely want a lawyer to help you, a specialist lawyer. Where are you going to find such a specialist lawyer? Well, again, there's a list on my blog. You will probably want a solicitor, because only solicitors can access legal aid. And that is how most judicial review cases are funded. So what will happen is the family will approach the solicitor, and the solicitors will, if they've got the legal aid contract, will work out whether or not the family are eligible for legal aid. Now, eligibility for legal aid is complicated because the parents' means are often taken into account. Not always, and there are ways in which social care cases, for example, can be brought based on the means of the child. What I would suggest is, if you are concerned or you have reason to believe that you may need to bring a judicial review, then you are going to want to get advice as quickly as possible, because there is a very tight time scale for judicial review. The requirement is to issue the claim promptly after the grounds of claim first arose, and no later than 3 months from that date. People often say the time limit is 3 months, but it's not. It's promptly and no later than 3 months. And you can be out of time even within the 3 months. So you will want to get advice as quickly as possible if you think you might need to bring a judicial review. For example, if you're being told we don't assess, or there seems to be some kind of policy or blanket rule that might be unlawful. But of course, we hope that through dialogue and discussion and people flagging up the law, then you'll be able to persuade the local authority to do the right thing without needing to go to lawyers. But we're here as an emergency service, essentially, when things are going badly wrong. So another question that's asked is, can we give details of case law? So I can show you again some useful resources in that respect. So first of all is my book that I co-author with Luke Clements, Professor Luke Clements, and supported by a number of other lawyers as well. Disabled Children, a Legal Handbook. And there is a chapter in the handbook that's specifically on social care, another chapter that's specifically on health, and also a chapter on transition to adult services that covers the transition process around social care, health, and education. So you'll see as you scroll down the screen that there are downloads available for each of the chapters. So you can download free of charge, for example, the Children's Services chapter here, which is the social care chapter. And hopefully that's a useful resource. If you'd like to buy the book, then it's available from Legal Action Group, our publishers. Here, and you can buy either the hard copy or the ebook. But although we've made it very cheap for a law book, it's still quite expensive. So that's why we wanted to work with the Council for Disabled Children to put the book online free of charge as a resource for everyone to use and to access. The other resource that I think is going to be helpful, particularly on the question of the case law, is we've done a directory of case law, because clearly we can't update the book every 10 minutes when a new judgment comes out. And so this link here is to our case law directory, which has various fields that you can search. So there's one on social care, for example. So all the cases that deal with that create principles, essentially, that are of wider significance, we seek to summarize in the directory, and some more judgments are being summarized shortly. So there's a list of resources that are hopefully going to be helpful for people as well. Just a reminder, please do put anything you want me to see or respond to in the Q&A rather than the chat. Thank you very much for the person who said that the handbook is very useful and saves costs before judicial review. We very much hope so. I'll come back to some questions in a moment, but I want to make a little bit more progress because some of the issues that you're asking questions about are picked up in later bits of law that we need to look at now. So let's go through the rest of the key provisions of the Children Act before we go off to the Chronically Sick and Disabled Persons Act. So we see now that after section 17, there's this alphabet soup of duties that now follow, inserted by later bits of legislation. And the first to look at is here in 17ZD, we have the duty to carry out a parent carer's needs assessment. So the local authority must, if the conditions below are met, assess whether a parent carer within their area has needs for support, and if so, what those needs are. The parent carer is an adult who provides or intends to provide care for a disabled child for whom they have parental responsibility. The conditions are very, very minimal. So the first condition is that it appears to the authority that the parent carer may have needs for support. Well, I'd suggest that's 100% of parent carers of disabled children would fit that. And or B, that they ask for an assessment. If the parent carer asks to be assessed, then that meets the first condition. The second condition is that the local authority is satisfied with the disabled child cared for and the family of persons for whom they may provide services under section 17, which again we've seen is very broadly drawn. So essentially, it's an on-request duty, and indeed local authorities should go out and actively offer parent carers needs assessments to people who may have needs for support. Now, the local authority doesn't have to do a PCNA if it appears to the local authority that they've previously carried out a care-related assessment of the parent carer in relation to that child and there's been no change. And those are either a parent carer's needs assessment itself or a Carers Act assessment or an assessment under the Care Act. Otherwise, they must do so. And they must have regards to the well-being of the parent carer and the need to safeguard and promote the welfare of the child. So it's a holistic view. And of course, the parent carer, the child, and anyone else who is requested to be involved must be involved. And it must lead to a written record of the assessment. So that's section 17ZD. And just for those that are involved in local groups, quite important to look here at 14, that the local authority must take reasonable steps to identify the extent to which there are parent carers in their area who have needs for support. So that's a conversation you might want to have with your local authority about whether they've been doing that more generally. But for individual parent carers, you can just ask for a PCNA to be done. Now, what happens at the end of a PCNA? Just before we get there, just a couple of supplementary points in 17ZE. Very importantly, that assessments can be combined. So if the local authority are required to carry out the PCNA and are required or have decided to carry out some other assessment of the parent carer or the disabled child, they may combine the assessments. So what the Act is pointing towards is a streamlined and joined up process where the child is assessed and the parent carer is assessed, not necessarily together in the sense of one document, but as a combined, joined up process. And although there's a power here to make regulations, to make secondary legislation that expand on these duties, that hasn't been used. So there are no regulations in relation to parent carers needs assessments, although there are, interestingly, in relation to young carers assessments, the equivalent provision for young carers. Where is all this going? It's going to section 17ZF. What the local authority must do is consider the parent carers needs assessment and decide a number of things. So at the end of the PCNA process, they have to make a number of decisions. Whether the parent carer has needs for support in relation to the care which they provide or intend to provide, whether the disabled child has needs for support. If so, whether those needs could be satisfied wholly or partly by services under section 17. And then if they could be, whether or not to provide any such services in relation to the parent carer or the disabled child. So there's not a duty to actually provide the services. There's a duty to make a decision as to whether or not to provide them. And that decision, as a matter of public law, must be rational and reasonable and fair. And in terms of those concepts, those principles of public law, we deal with those, sorry, the wrong link, in the handbook in chapter 2. We've got a chapter called Legal Fundamentals, which goes through those kinds of public law principles and explains them. So if you're not clear what it would mean to make a rational decision, then we look at that in the handbook. So the PCNA duty is useful for families, but it's only useful if it's done properly, I suggest, because it doesn't result in a right to services. What it results in is a requirement to have a holistic decision-making process, where the disabled child's needs, any parent carer's needs, and through the young carers process, any siblings' needs are looked at, and then a joined up decision made at the end. So just looking at the questions that have come in now, can we have an updated list of solicitors who have legal aid capacity? That's the list I've just sent you. So on my blog, I've put a list of the solicitors that I've worked with who have legal aid contracts in this area. Whether or not they have capacity, of course, will depend on, at that particular time, what else they've got on. And they are all extraordinarily busy. But all I can suggest is that those, and indeed any others that people can suggest, are contacted. I can only put on the blog those that I've worked with, of course. There's questions that are rather too specific, I'm afraid, for me to answer, like a particular local authority won't do a particular thing. I'm not going to be able to answer those, but do feel free to frame more general questions. And again, I'm afraid a question is about a specific case where a particular seemingly very unfortunate thing has happened in relation to social care provision. I'm not going to be able to answer that today, I'm afraid. What I would say is that any of those situations, again, people need to access urgent legal advice. A more general question, what sort of things can be offered to support the carer following a carer assessment? And the example that's given is you can have £500, otherwise go away. Well, clearly that isn't necessarily going to be good enough. So what you could do, I mean, the most obvious thing that you can do as a local authority to support carers is provide short breaks, provide services to the child, which allow the carers to have a break from caring. And we'll see in a moment the obligations that local authorities have in relation to short breaks that are specific. I'm being asked, Sharon, if we can put the captions on. I'm not able to do that, I'm afraid, but if you're able to do that, that would be very helpful. So what can you do if you request an assessment but never do one? They never do one. That's exactly the kind of situation where you'll need to get advice from a legal aid solicitor about a potential judicial review. Question about are there slides? No, as I said at the beginning, we're only going to be looking at the law itself today. There's no slides to catch up on, but the talk is being filmed and so will be available, or recorded, sorry, will be available on the Seashore Trust YouTube channel. A question, how do you prove the needs of children and families during a social work assessment effectively so as to get provision? Great question. So the purpose, as we'll see, of an assessment is to understand and evaluate the needs of the child and family. And that is supposed to be a matter for the social workers using their professional expertise. Families can, of course, ask for an independent social worker to carry out an assessment, but there's a cost associated with that. And unless you're in legal proceedings and you can get legal aid funding for that assessment, that probably won't be available for many families. And so what I would suggest is it's a matter of the family making clear in the assessment process what the needs are and making sure that they've written down and kept a record of, for example, sleep disturbance. Exactly how often does the child wake up in the night, to pick one example. So to clarify, to provide the evidence that the local authority are going to need. A question about if we don't qualify for legal aid, how can we find a list of solicitors we could pay ourselves? So on the blog, I've also put solicitors who don't have legal aid contracts, who have specialism in this area. But the problem you're going to have is that judicial review is a process where the loser is expected to pay the winner's costs, which is great news as a family if you win, of course, but very bad news if you lose, because you'd be expected to pay the local authority's legal costs, which can be tens of thousands of pounds. So it's very unusual that families are going to find themselves in a position where they can afford to pay privately for judicial review. You may need to pay privately to send a letter before action, and it can often be sufficient to send that letter to get local authorities to get moving, for example. and letters for action don't result in any liability to pay the other side's costs. But once you issue the judicial review claim, then you are liable to pay the other side's costs if the claim is withdrawn or if it fails. So without legal aid, it's extremely difficult. The other thing that people have been using is crowdfunding, and there's a website called Crowd Justice where people can ask for support, financial donations for litigation. That tends to be rather more effective if you've got a policy challenge, so to either national or local policy or to legislation using the Human Rights Act, for example. But have a look at the Crowd Justice website if you're considering whether that might be an option for you. And another question, which is, can you get a judicial review without a solicitor? I would strongly advise not to. It's an extremely bad idea to approach the High Court without a lawyer, a specialist lawyer involved. You can instruct a barrister, myself, without a solicitor involved. That's called direct access, but we can't get legal aid. Only solicitors can get legal aid. So people are maybe struggling slightly with the links. If you can't see the link for the solicitors, if you just search rights in reality, which is the name of my blog, and then the phrase solicitors will be the first link that comes up. So that should hopefully allow you to find it. And similarly to how do you access my blog, search the phrase rights in reality, and I hope there'll be some useful resources there as well. Is there a minimum age for a child in need assessment and or services to be provided for children in need? Absolutely not. No, you can be a child in need from the day you're born. So no, there certainly is no minimum age. What was the letter I just mentioned? So that's a letter before action. So on my judicial review blog, I talk about the fact that the first stage in the judicial review process is to send a formal letter, usually be written by your lawyers, explaining why the public body has got it wrong and what they should do to put it right. And you really must send that letter, because otherwise it's very likely that the court will refuse permission for you to be allowed to proceed with your judicial review. And in a large number of cases, that is enough to resolve the problem. It's only a minority of cases where you then have to bring, actually issue the claim. Can you do a judicial review in your child's name? Yes, you can. So the vast majority of social care and health judicial reviews will be brought by children themselves, because they are the primary victims. In education, it's rather more complex, because some of the education rights actually rest with parents. But for social care and health, it will usually be, my client will normally be the child. But of course, children generally, and disabled children in particular, won't have capacity to give instructions. And so the instructions are given by a litigation friend. And that's the person who essentially represents the child or a protected party if it's an adult who lacks capacity, and gives instructions on their behalf. So I will act for child A by his mother, usually, as a litigation friend, and the legal aid will be in the child's name. That's the usual way in which proceedings are brought. But again, the short point is, go and ask a solicitor to advise you on these points if you are concerned about them. Should parents be given carers assessments and support, or does this only apply to children's social care? And as I was just showing people, I hope, within section 17, ZD, ZE and ZF are these entitlements to parent carers needs assessments. So absolutely, parent carers of disabled children should be given assessments and support where the assessments indicate that that's necessary. Now, there isn't a duty, as we saw, to a specific duty to provide services to parent carers of disabled children. But as a matter of rationality, if the assessment shows the family are at crisis point, and if by providing services to the family it's going to help keep them together, then in accordance with the general duty in section 17, which it requires the local authority to focus on promoting the upbringing of children with their families, it may well be irrational for them not to provide services to that family. So it's not perfect as a set of legal entitlements, but very often we will persuade local authorities they do in fact have to provide services to parent carers or to the family as a whole. So other important parts of the Children Act 1989, I mentioned already of direct payments under section 17A. The local authority may, where it's going to provide services to the disabled child, instead provide direct payments. So direct payments are just a mechanism of discharging the duty to meet the child's needs. We won't spend too long on the technicalities of direct payments. They are very technical, but they exist as one way of meeting needs, but they cannot be enforced. You can ask for a direct payment, but if you don't want one, if you want the local authority to arrange the services instead, then they must do so. Then we have duties in relation to accommodation for children in section 20 of the Act in particular. And we'll look at that in a moment. But what I just want to show you before is there's then all this whole set of duties here around section 22 that are relate to looked after children, which include those children accommodated under section 20. And so very important obligations in relation to that cohort of children who are looked after by local authorities. That's both those who are subject to a care order made by the family court, but also those who are provided with accommodation under section 20. And we see under section 21, every local authority shall, so it's a duty, provide accommodation for any child in need within their area who appears to them to require accommodation as a result of any of these three things. And the one that's particularly relevant for disabled children is C, the person who's been caring for him being prevented, whether or not permanently and for whatever reason, from providing him with suitable accommodation or care. So where families are sadly at crisis point, the section 21C duty will kick in and the local authority would be required to provide such accommodation as is necessary to remove the crisis, to allow the parents to continue to provide the child with suitable accommodation or care. And the critical point about section 20 accommodation is that it's voluntary. Parental responsibility doesn't shift to the local authority. The parents can terminate it at any time. It's a choice for the family. The effect, though, of being accommodated under section 20 is that you become a looked after child for the period of your accommodation. And that's a good thing because it gives you additional entitlements and safeguards. And there are a series of regulations that have been made around looked after children called the care planning regulations. Regulation 48 of the care planning regulations sets out a modified form of looked after status for children who are disabled children, primarily who are being accommodated in respite short break accommodation, where there are less intensive review and care planning processes, but nonetheless still very important, extra additional safeguards for children who are away from home. So section 20 and the care planning regulations is a vital part of the mix, the statutory mix for this particularly needy group of disabled children, although the vast majority of disabled children, of course, won't be accommodated under section 20. So going back then to the provisions of the Act that are more generally applicable, and I'm scrolling down now to the schedule. So the way that legislation often works is you get the detail in the schedules. So here we have in Schedule 2, support for children and families provided by local authorities in England, and this sits under the section 17 duty. And in terms of assessment, we see that local authorities have to take reasonable steps to identify the extent to which there are children in need within their area. So that's part of the reason why the House of Lords found in the G. and Barnett case, there was a duty to assess. Maintenance of a register of disabled children. Every local authority shall open and maintain a register of disabled children within their area. This is still in force. Rather wonderfully, the register may be kept by means of a computer. Bit of luck in the modern world, of course. And then we see here that where it appears to a local authority that a child within their area is in need, the authority may assess his needs for the purpose of this act at the same time as any assessment of his needs is made under any enactment. In particular, here's our first reference to the Chronically Sick and Disabled Persons Act 1970. So we're going to look in a moment at the CSDPA 1970, which itself doesn't actually contain an assessment duty. And so the way that we say that the scheme works is that the assessments are carried out under the Children's Act 1989, and then the CSDPA provides the duty to provide services to children who meet the criteria within that act. We'll look at that in just a moment. Before we get there, though, I mentioned already the short breaks duty. That sits in paragraph 6 of the schedule. We see provision for disabled children is specifically indicated here. And every local authority should provide services designed, rather old-fashioned language here, to minimize the effect on disabled children within their area of their disabilities, or rather medical model, to give such children the opportunity to lead lives which are as normal as possible. Again, perhaps not language we use now. And then the new bit that was added in 2008 to assist individuals who provide care for disabled children to continue to do so or to do so more effectively by giving them breaks from caring. So that's the short breaks duty. And we see there's a reference here to regulations, and the relevant regulations are the breaks for carers, children regulations. Now, they are. So I'll go to these. I'm not generally going through the secondary legislation because of time, but these are very short and they're quite important, as we say. And so there's only 3 substantive regulations here. Regulation 3 says that in performing that short breaks duty we just looked at, the local authority must have regard to, so that means consider, the needs of carers who are would be unable to continue to provide care unless breaks from caring were given. That's crisis short breaks. And importantly, have regard to the needs of parent carers who would be able to provide care for their disabled child more effectively if breaks from caring were given to allow them to do these ordinary life things, undertake education training, regular leisure activities, meet the needs of other children, or carry out day-to-day tasks. What's not in that list is childcare. And the reason for that is because the childcare is the service that supports, what's not in the list is employment, is work. And that's because work is the service that is supported by childcare. And so childcare is legally a distinct thing to a short break. Families may well need both, of course, because they'll need childcare to work and short breaks to live essentially ordinary lives. And that's what Regulation 3 here is saying, that local authorities must think about the needs of carers to live ordinary lives. Regulation 4 then imposes a sufficiency duty on local authorities. They must provide, here we see, so far as is reasonably practicable, a range of services which is sufficient to assist parent carers to continue to provide care or do so more effectively. And that must include daytime care in the home or elsewhere, overnight care in the home or elsewhere, educational or leisure activities outside the home, and services for the evenings, weekends, and school holidays. So within the mix must be all these things. And so far as is reasonably practicable, what's provided must be sufficient to meet the needs of parent carers in a local area. And that all then has to be set out in the short break services statement that's required by Regulation 5. So a local authority must prepare a statement for carers in the area, a short break services statement, setting out details of the range of services, any criteria by which eligibility for those services will be assessed, and how the range of services is designed to meet the needs of carers in their area. So if you're interested in short breaks in your local area, the document that you need to look at is the short breaks services statement. So that takes me through what I wanted to show you in the Children Act 1989. What I'm going to do now, before I look at the questions again, is just show you the duty in the Chronically Sick and Disabled Persons Act. Just pausing to note, isn't it astonishing that I'm now talking to you about legislation that is over 50 years old and is still the key duty for social care provision for disabled children. So here we have the CSDPA as it currently stands, been repeatedly amended, of course. And we're concerned with subsection 4. And it says, where a local authority has functions under Part 3 of the Children Act 1989. So we see straight away that we're looking at children in need, because that's what Part 3 of the Children Act 1989 is about. In relation to a disabled child, and the child is ordinarily resident in their area, they must, a duty, in exercise of those functions, make any arrangements within subsection 6 that they're satisfied it is necessary for them to make in order to meet the needs of the child. So that's the legal test. Having done an assessment, the local authority have to decide, is it necessary for, and that means more than desirable, of course, for us to provide any of these services, make any of these arrangements in order to meet the child's needs. And we see the list in subsection 6 is very broad. Practical assistance for the child in the child's home. So that's domiciliary care. The provision of wireless, which probably has a rather different meaning now, television, library, or similar recreational facilities for the child, or assistance in obtaining them. The provision for the child of lectures, I'm sure our children would love lectures, games, outings, or other recreational facilities outside the home. So that's short breaks in modern language. Or, interestingly, assistance to the child in taking advantage of available educational facilities. So the link there to education. The provision for the child of facilities for or assistance in traveling to and from the home in order to do any of these things. So there's a transport duty here in order to access any short breaks or other social care services. E, the provision of assistance for the child in arranging for the carrying out of any works of adaptation in the child's home, or the provision of any additional facilities designed to secure greater safety, comfort, or convenience. Now, adaptations are generally dealt with through the Disabled Facilities Grants Scheme, which is a non-means tested scheme for disabled children and allows for up to £30,000 of funding for adaptations. But if for some reason that's not available or not enough, then the local authority may, under subsection 6E, have to provide further assistance to fund adaptations or to arrange funding for adaptations. And that could, for example, involve a loan being made to the family. So again, another very important aspect of the duty here. Facilitating the taking of holidays by the child. Now, holidays are generally seen as being something the child does together with the family, but they don't necessarily have to be. And the case law shows that that can include the basic cost of the holiday as well, if it's necessary for the local authority to fund it. Keeping in mind that one of the indicators of absolute child poverty is never having an annual holiday. That may well be necessary to support the cost of a holiday for the child. Provision of meals for the child, whether at home or elsewhere. Sadly, that may be relevant in the modern climate. And provision of a telephone or special equipment necessary to use a telephone. So those are the things that needs to be provided under the CSDPA if the local authority assesses that it's necessary for them to be provided in order to meet the needs of the child. And I suggest that within that list, you can find everything that disabled children may need in terms of social care support, apart from accommodation. You cannot get accommodation under the CSDPA. And that's why it's so important that we have the duties to accommodate in section 20 of the Act and the power to provide accommodation under section 17 of the Children Act, because accommodation is dealt with separately. So that's the whistle-stop tour of the CSDPA. The next place we're going to go is to the Working Together Statutory Guidance. Before we do that, I'll just review the questions as well. So who undertakes an assessment in relation to a disabled facilities grant? We look at the disabled facilities grants in detail in the housing chapter of the handbook. It's an assessment undertaken by the local authority, in short. Is it a legal requirement to have a short break statement? Yes, we just saw it. It's in Regulation 5 of the Breaks for Carers of Disabled Children Regulations 2011. Do the adaptations duties cover autistic children? Yes, absolutely. Of course they do. Does the CSDPA cover post 16? Yes, again, like the Children Act 1989, it goes up to 18. So we'll look at the Care Act provisions for 18 and above a little later. But the CSDPA and the Children Act 1989 are for everyone up to their 18th birthday in this respect. Can a local authority refuse to provide short breaks if services in the borough don't have a space? No. So we see that the duty in the CSDPA is not contingent on the availability of any particular kind of provision. They've just got to make any arrangements that is necessary for them to make. And the local authority would have to fund another kind of service or offer direct payments if there's a waiting list for a particular service. Why are short breaks provided under section 17? Why not under the CSDPA? They are provided under the CSDPA. So the critical word that you need to see in subsection 4 of the CSDPA is this, where a local authority has functions under Part 3 of the Children Act 1989. So the CSDPA duty requires the exercise of the functions in section 17. Local authorities seem to get this very confused and think that there's some sort of choice between the two, but there isn't. The CSDPA duty sits on top of the Children Act 1989, and all it does is it turns a general duty into a specific duty for a child where the local authority has assessed that it's necessary for them to meet their needs in order to provide that, by providing that service. Can a local authority refuse to assess if the child is 17 years and 6 months? No, they are a child in need. What about if the social worker dismisses needs as a result of an assessment? So when you get the assessment back, obviously you should have the opportunity to comment on it in draft. If you think it's completely wrong or misleading, and then you've got the same two choices I discussed before. You can either make a complaint through the local authority complaints process, or you can look to bring a judicial review challenge to the assessment. Now, it's difficult because, of course, judicial review is a bit of a sledgehammer. But if there's a very serious and urgent problem, then absolutely it would be appropriate to take advice on whether or not you can challenge it by way of the CSDPA. Sorry, by way of judicial review. Is there an independent body in relation to the complaints procedure? Yes, there is eventually. So you have to go through the local authority stages of the complaints process. But then ultimately your complaint goes to the local government and social care ombudsman, which is different from and independent from every local authority. An excellent question. What's the difference between will, shall, should, and may in legal terms? So what you're looking for is mandatory language. So must and shall impose duties because they are absolute. May creates a power because may implies may not, so it implies a choice. So of course, if a local authority have a power to do something, they have to consider whether or not to do it. And not to even consider whether to exercise the power is what's called fettering of their discretion, which is unlawful and can be judicially reviewed. But it's clearly much harder to make a local authority do something if they've only got a power to do it than if they have a duty to do so. A couple of questions about adult care. I have said already, and I'll say it again, I'm coming on to the Care Act, which we'll cover after the break. A question about Regulation 3 of the short breaks regulation, which is that, if people remember, is the things the local authority have to consider. It doesn't create a duty to provide any of those things. But what it does show is that local authorities have to have the sorts of services available that will support parent carers to achieve those kinds of ordinary life outcomes. It will be difficult to enforce legally. So another question about challenging and enforcement, suggesting that for social care disputes, it's complaint first, then use judicial review. No, really important point. You cannot do them in stages. They are alternatives, because if you make a complaint, you'll be out of time to bring a judicial review. And if you bring a judicial review, the ombudsman won't look at the complaint. So the message is get advice as quickly as you can. And yes, it's correct, unfortunately, that availability of advice via legal aid is limited, and it may well be a question of calling around and persisting, but that is all I can say in terms of what people can do. The answer is, if you're unhappy about the support that you're being provided, then you must get advice as quickly as you can. And that picks up the question about what happens if a local authority is dismissive of a child or parent's needs. Again, get legal advice as quickly as you can. What's the difference between a personal budget and a direct budget? So the language here is that a personal budget is a way in which a sum of money is identified as being available for the provision of services for a child. And that may or may not be transferred to the family in the form of a direct payment. So a direct payment is one kind of personal budget, and it's the kind where the family actually get the money. I was going to say the cash, but of course it will be a bank transfer these days to spend on the provision. Otherwise, you either have a notional personal budget where there's an amount of money that's identified, but the local authority continues to commission the services, or a third-party budget where it's transferred to a provider, for example. So those are different forms of personal budget, but often what people are concerned about is, can they get a direct payment? A question about Section 20, the duty to accommodate. Can that result in a child being removed because of their behaviour or chaotic family life? Well, yes, it can, but only with agreement from the parents. So it's very important that Section 20 isn't misused as a sort of light form of child protection process. And the courts have been very critical of local authorities who've misused Section 20 in that way and said, no, you need to take care proceedings because people need to have the right to challenge, including the child, but also the parents, any decisions that are being made. So Section 20 is, as I've stressed, voluntary accommodation. Is there a financial assessment if the parents' needs are to be met? No. So as I say, in the vast majority of cases, in fact, universally, as far as I know, social care services for children and families are not charged for. If you are told there will be a charge, that would definitely be a question on which it would be worth seeking legal advice. And then a fantastic question that I knew would come up. If the local authority is doing an EHC plan or an EHC needs assessment, should they have done a child in need assessment? Not necessarily, but, and I will just take us into this because it's so important. If a local authority is carrying out a EHC needs assessment, it needs to get the advice that it's required in Regulation 6 of the SEND regulations. And that includes, as we see here, advice and information in relation to social care. And that has to be on the needs, the outcome, the provision, and the outcomes. What is not good enough, in my view, is a local authority writing to itself, so the education department writing to children's services and saying, please tell us about Johnny's social care needs, and the social care department writing back and saying, we don't know Johnny, child not known. There must, I would suggest, at least be an offer of an assessment in that context. And if the family say, well, we don't want one because we don't have any interest in social care, that's fair enough. But to simply say not known isn't good enough. So they don't necessarily have to do a full child in need assessment unless that's what the family want. But there must be a gathering of sufficient information to be able to provide the advice that's required by Regulation 6. And in my view, they would have to at least offer a child in need assessment. So if needs are assessed during the assessment process and set out in the assessment, but no provision is offered, then what can be done? Well, again, that would be either a complaint or judicial review. And at that point, I think it probably is sensible to go and look at the guidance just to complete the picture in terms of the essential points. And the Statutory Guidance on Disabled Children's Social Care is working together to safeguard children. Now, there's a lot of good stuff in working together, but it's fundamentally problematic, I would suggest, because it's trying to do two things. It's trying to be guidance on children in need, but also, as the name suggests, guidance on children at risk. And there used to be separate guidance in terms of children in need, called the Framework for the Assessment of Children in Need. But that was scrapped as being too long and bureaucratic, and instead we just have this single guidance document. And there is an overwhelming focus, I would suggest, on safeguarding within this. Having said that, it can still be made to work and still has useful content for families of disabled children who don't have, well, there are no safeguarding concerns. And one thing that's very important to identify, first of all, is what's this thing called early help? So early help is a process that's been created, policy process, not set out in legislation, which is intended to support children before they become children in need. And we see that the legislation that it's hooked to is Section 10 of the Children Act 2004. Now, this was the landmark legislation that led to, around the Every Child Matters programme, which was all focused on cooperation and interagency working, leading from the tragic death of Victoria Climbié. And Section 10 is, as the guidance says, a duty to cooperate to promote children's welfare. So it's a broad cooperation duty. And the idea is that the early help process will support, as I say, children who are not yet in need, but who may become in need. But of course, that doesn't work for disabled children because they're all automatically in need. So I'm very skeptical about the relevance of early help for disabled children, even though it does say within the guidance that they're a group who may be relevant for, because they are all automatically children in need. And so therefore, we need to look at the statutory requirements for children in need. And we see the local authorities undertake assessments of the needs of individual children, giving due regard to their age and understanding. Every assessment must be informed by the views of the child. Child's wishes and feelings must be sought regarding the provision of services to be delivered. Where possible, I would suggest that should say appropriate, children should be seen alone. We know that children in need include all disabled children. We know that some of them may require accommodation. Specialist assessments may be required. And then this is the gateway to child protection concerns. Under Section 47, the local authority must carry out investigations if it has reasonable cause to suspect that the child is suffering or is likely to suffer significant harm. That's the key. But that won't be relevant, happily, for many families of disabled children, of course. There's then a specific bit of the guidance here on assessment for disabled children. And what it says, thankfully, is what I've just explained in terms of the link to the CSDPA. So when undertaking an assessment of a disabled child, the local authority must also consider whether it's necessary to provide support under the CSDPA. Where a local authority is satisfied the identified services and assistance can be provided under Section 2, and it's necessary in order to meet a disabled child's needs, there's that key phrase I keep banging on about. It must arrange to provide that support. And where a local authority is assessing the needs of a disabled child, a carer may also require the local authority to undertake an assessment under Section 1 of the Carers Act. And if a local authority considers that a parent carer of a disabled child may have support needs, it must carry out a PCNA assessment. So the Carers Act duty is really only relevant for non-parent carers, for example, grandparents. Otherwise, it will be a PCNA. So there's a potted summary there of the law on disabled children, which is broadly helpful, I would suggest. And then the requirements in terms of young carers are set out in the guidance here as well. We then see the purpose of assessment. Whatever legislation the child is assessed under, the purpose of the assessment is to gather important information, analyze their needs. That's really key. The assessment must result in analysis, not just a description, and or, importantly, the nature and level of any risk and harm. Decide whether the child's in need or is likely to suffer significant harm. And then finally, to provide support to address those needs to improve the child's outcomes and welfare, and where necessary to make them safe. Local protocols for assessment. So every local area must, under the guidance, must publish local protocols setting out clear arrangements as to how cases are managed. So you should be able to understand how the process works in your local area. And then there's, including the complaints process. And then there's guidance on what a good assessment might look like. And importantly, good assessment support practitioners to understand whether a child has needs relating to their care or a disability. There's a specific focus there. The specific needs of disabled children should be given sufficient recognition and priority in the assessment process. And what we're going to come to after this list of what high quality assessments look like is the assessment framework, which is from the old guidance that is recommended still as the model that's used. So we see that the child's developmental needs come up one side, parenting capacity, and then family and environmental factors, with the duty to safeguard and promote the welfare of the child always at the centre. And so the assessment process is supposed to look at all of these different factors, even if only briefly, as appropriate for the child. Developing a clear analysis is vital. The social worker should analyse all the information gathered from the assessment, including any young carers, parent carers, or non-parent carers assessment, to decide the nature and level of the child's needs and the level of risk, if any, they may be facing. An informed decision should be taken on the nature of any action required and which services should be provided. The analysis should inform the action to be taken, which will have maximum impact on the child's welfare and outcome. So those are all very important points, as is this section here on focusing on outcomes. Every assessment should be focused on outcomes, deciding which services and support to deliver improved welfare for the child. So that's the goal. And then importantly, where the outcome of the assessment is continued local authority children's social care involvement. The social worker should agree a plan of action with other practitioners and discuss this with the child and family. The plan should set out what services are to be delivered and what actions are to be undertaken by whom and for what purposes. So that duty to have a child in need plan is actually only found here in the guidance, but working together is very important guidance because it's issued under a whole raft of different statutory provisions, including Section 7 of the Local Authority Social Services Act 1970. And Section 7 guidance, as it's known, is guidance that local authorities have to act under. And that means they have a duty to do what's in it unless they take a considered decision that they've got good reason not to do so. And in practical terms, I've never known a local authority argue that. They will always say we have complied sufficiently with the guidance. So if it's in the guidance, if this guidance, which has that kind of legal status, it comes very close to being a legal requirement. And we see that the plan should reflect the fact that services will be provided for parents or carers and set clear measurable outcomes for the child and expectations for the parents, which is one of the places where the guidance really, I think, does overly focus on risk and safeguarding as opposed to the importance of provision for children in need. Timeliness, this is very important, of course. How long do local authorities have to do these assessments? Well, we see in paragraph 78 of the guidance, within 1 working day of a referral being received, the social worker should acknowledge receipt and make a decision about next steps, including any immediate services that need to be provided. So there's an immediate requirement to respond. And then in terms of the time frame for the assessment to conclude, such that it's possible to reach a decision on next steps, should be no longer than 45 working days from the point of referral. So that's the maximum time frame for children's assessments. And then there's some very helpful flow charts. This one here deals with the initial referral process. Skipping over immediate protection, we come to this guidance on assessment of children in need. And so following acceptance of a referral by children's social care, a social worker should lead a multi-agency assessment under section 17. Local authorities have a duty to ascertain the child's wishes and feelings. Again, assessments to be carried out in a timely manner. And then where services are being provided, a multi-agency child in need plan should be developed. Where a child's approaching 18, this transition point should be planned for in advance. We'll come on to that. And if there's a risk, if there's identified risk, then we move into the section 47 process instead. Social workers should lead on an assessment and complete it in line with the locally agreed protocol, according to the child's needs and within 45 working days. See the child in an appropriate timescale, interview with the child and family members separately and together as appropriate, importantly, minimizing distress to children, maximizing likelihood they provide good information, record the assessment findings, decisions, and next steps. Inform in writing all relevant people. Hopefully, we're not concerned with what the police should be doing. And then we come on to the flow chart. So as we see, the assessment led by a social worker, completed in line with local protocol, including a decision on course of action within 1 working day of referral, followed by a timely assessment based on the needs of the child within 45 working days. So that's your time frame. Either there's going to be no social care support, but onward referral, or social care support is required. Hopefully we're in the no actual or likely significant harm box. So we then move on to social worker discussing next steps, including review decision point. Assessment continues, services provided if appropriate, so there's no need to wait till the end. Social worker with the family other professionals agrees the next steps within 45 working days, could agree the child in need plan or if appropriate child protection plan, and then review the plan and outcomes of the child. When appropriate, refer to non-statutory services, e.g. step down. Of course, you have to be very careful with the disabled child because they will still be a child in need. So that's what the guidance adds to the overall social care process. So I'll go on and see if there's any more questions about that before we have a break. A good question about training and expertise. Yes, the guidance says that the people carrying out the assessment should have appropriate expertise, and it's perfectly reasonable to ask about that. It's not necessarily the case that every assessment has to be carried out by a social worker, a qualified social worker, because in a case I was involved in, Miss Justice Mostyn said that wasn't right, but the guidance does repeatedly suggest that it's going to be a social worker doing, or at least I would suggest supervising the assessment process. And certainly whoever's doing the assessment should have appropriate training. Is 2 or 3 months timely? Well, no, because the requirement is to carry out the assessment within 45 working days. So that's your backstop. Can this document be added to the chat? Certainly can. Thank you very much. This is the working together guidance here. There you go. That's the link to working together. Local authorities and social workers stating their training and experience is personal data and therefore isn't available. Well, I would be very skeptical about that answer, and it's one on which legal advice I would suggest should be obtained. And of course, if there's ultimately a dispute about data protection issues, that can go to the Information Commissioner. But within the context of a child in need assessment, I think it's something that it's worth getting advice about in relation to the to the social care side of things, I suppose, not necessarily going off to the Information Commissioner, but thinking about judicial review. The question about the national trial within the tribunal process. So again, focus there not being on the EHC plan, but just to mention the fact that if you appeal to the tribunal in relation to the education aspects of an EHC plan, you can also ask the tribunal to make recommendations in relation to social care and health. And that can be very effective. I don't know the statistics of the success rates, but I know that families have got very helpful recommendations in terms of what the social care needs should be or what provisions should be. But it isn't required for the local authority to follow those, obviously, their recommendations. If they don't, then you can potentially challenge that through a complaint or through judicial review. But I would suggest in many cases, it's better to just go straight for a child in need assessment and to challenge any resulting decision. A question about education post-18. I'm afraid that's not the subject of today's talk. The answer is that EHC plans can extend up to 25. So you'll find all of that on the Children and Families Act and on the seminar on education. What about situations where people make a complaint and that results in additional scrutiny? I can't promise that local authorities will follow the law or the guidance. Of course I can't. What I can say is that my general experience is that where people seek to assert their rights, that results in better outcomes for them and for others. But there are, tragically, cases where I've seen families suffer detriments. And all I can say again is make sure you get legal advice. And if you feel you're in that position, that's exactly when you'll need to speak to a solicitor. I think there's a lot of questions coming in from one particular attendee, and apologies that I'm not able to answer all of them. Some of them are just too specific. Can direct payments only be awarded through a Section 17 assessment? Yes, because direct payment is a form of provision to meet assessed needs. Now, some local authorities will offer a non-assessed support service, short breaks, for example, either maybe 1 or 2 weeks, or an amount of money. They're perfectly able to do that and entitled to do that. As long as that's additional to the statutory process. So they can't replace their duties to carry out assessments and make decisions about packages of support by offering a fixed sum of money, for example. That wouldn't be law. Questions about local authorities refusing to provide a short breaks budget if parents refuse a particular placement. What do you do if your child appears to be shut out of services? Again, that's exactly the kind of situation where specific legal advice is going to be required. Is pressure to step down, i.e. end the child in need plan, appropriate for a child in need? I would suggest for disabled children, probably not, because it's very unlikely that the child's needs are going to get any less. And it's a well-worn path, isn't it, to say, oh, look, no, provision is no longer needed because things are going well, but things are only going well because of the provision. And so any attempt to step down a disabled child in need, I think, again, should be met with requesting some legal advice. Can a social worker say we only help with breaks or providing a PA, so domiciliary care, and not both? Well, I think we've made pretty clear that that wouldn't be a lawful response because the duty is to meet the child's needs as identified in the individual assessment. So very unlikely that that's going to be a lawful response to say we only do X or Y. Once a personal budget or direct payment has been agreed, can the local authority decide to stop this for any reason? Yes, it can. It can say the child no longer has eligible needs, or it can say the direct payment isn't being appropriately managed. And instead of making a direct payment, we're going to provide services instead. Again, in that situation, there would be the potential to bring a judicial review if that was a flawed decision. What would be the cost if you lost a judicial review? Well, tens of thousands of pounds. And if it goes all the way to a full hearing, and if the local authority instructs some sort of expensive QC, you could be looking at 50, 60,000 pounds or even more. Judicial reviews do go in stages, and the costs at the permission stage, the first stage, are much, much lower, but could still be in the thousands of pounds, will still be in the thousands of pounds. So it's not something that anyone should ever attempt lightly, I would suggest. What if you feel an appointed litigation friend is biased? Well, that's very interesting as a question, because litigation friends should be appointed by the solicitor in partnership with the solicitor. And very usually, in the kind of cases we're involved in, we're talking about here, it will be the parents. So you can challenge a particular litigation friend. And again, that's something on which case-specific advice will be needed. Now, what I haven't yet mentioned is continuing healthcare. And we will come on to that after we have our own break, as well as people have asked me to do, looking at issues in relation to post-18 as well. But I think I've been talking about the law for quite long enough now, without giving everyone their own short break. So I'm going to do that now. Thank you again for the questions that are still there. answering as many as I can, as people can see. Not obviously going to be able to answer every single one, but do please keep them coming. Again, please do keep them short and general if you can. What we'll do is we'll take a break now until 11:30 and then come back for the final hour. So I'm just going to turn off my camera and microphone, and we'll go quiet for 12 minutes, and I'll see everybody again at 11:30. Thanks, everyone. Right, hi everyone. Hope you were able to refresh yourself. We, of course, sadly can't offer virtual refreshments, but I hope you're feeling ready to go for the second half of this discussion, where we're going to focus on the move into adult social care and also look at continuing healthcare. So the first place to go then is to look at children's continuing healthcare. If we look at the national framework, on children and young people's continuing care. Now, the basic principle of continuing care for children, continuing healthcare for adults, is that there are some needs that are too intense for local authorities to meet. And as it sets out here, this guidance, this national framework, is about the process for assessing, deciding, and agreeing continuing care for children with complex health needs. What's really quite important about continuing healthcare and continuing care is that that complexity can relate to issues like behaviour and communication. So quite a lot of children, for example, autistic children, who wouldn't necessarily be thought of as having health needs, actually might be eligible for continuing care or continuing healthcare if an assessment is carried out. And under the national framework, which is 52 pages for children, it's rather longer for adults, we have this national process that was reissued in 2016 and already is becoming rather out of date, sadly. What's really interesting, I think, about this document is it's non-statutory guidance. It doesn't have any legal force behind it at all. However, in all the cases I've ever done, it's been treated as if it's statutory guidance. And so it's been very carefully followed, or at least any failure to follow it has been challenged. And we see that what's set out within the guidance is a definition of continuing care, the roles and responsibilities of clinical commissioning groups as they are currently, the continuing care process, and then we have the decision support tool. People might be aware of that, 10 different domains of need, including behaviour and communication. And it's supposed to give an indication as to whether the child or young person or adult, the adult framework, is eligible. It's not supposed to be the thing that decides eligibility. That's supposed to be a multidisciplinary assessment. But it's, I think, perhaps often rather used as being a decision-making tool as opposed to just a support tool, as its name suggests. So a continuing care package will be required when a child or young person has needs arising from disability, accident, or illness that cannot be met by existing universal or specialist services alone. Needs that are so complex they cannot be met by services that are routinely available from GP practices, hospitals, or in the community. Package of additional health support come to be known as continuing care. And this is the framework for up to 18. And the process here is then summarised in brief. The assessment, led by the children and young person's health assessor, drawing on advice from professionals. It could be a pre-assessment to determine whether or not a full assessment is necessary. Looking at these four areas: the preferences of the child or young person, family, holistic assessment of need, reports and risk assessments from a multidisciplinary team, and the DST, the decision support tool. And then there's a recommendation, eligible or not eligible. Then a decision-making process where a multi-agency panel decides whether or not the child or young person has a continuing care need. And if they do, there's then a package of care put in place to meet those needs, which will be, I would suggest, led by the CCG, as it says here in paragraph 12. Following an agreement on the package of care, the CCG, and where relevant, the local authority, make the necessary arrangements to deliver the package of care. So it's very important that the right children are assessed for eligibility for continuing care, because it brings in NHS money to the system. And otherwise, these children who will, by definition, have more complex needs will be taking a very significant amount of the local authority's budget. And it may not be appropriate for the local authority to be providing them with support at all. And we know that because of the Haringey judgment, which we have here in Annex C of the framework, which is a summary of Deegan Haringey, which we talk about, of course, in the handbook as well. What was happening in D was there was a very young child, 3-year-old child, who needed a lot of care, including at night, including in relation to their tracheostomy. And the question was, well, who's responsible for providing short breaks respite care to this family, and how much should they get? And we see that there was a dispute both about who was going to, which statutory body was responsible for it, and the quantum, the amount of care. And what the judge said was that this was care that went beyond what a local authority could provide. The purpose of it, although it was described as respite care, it was actually to deal with the continued medical consequences of the operation, which, if not met, would give rise to urgent or immediate medical needs. And the gravity of the consequences of a failure in care and the duration of it meant it was more a medical service than a social services provision. And so not only, as the guidance says here, did the judge find that there was no duty to provide the services on the local authority, in fact, they were not able to do so. There's a quote that's frequently used, here it is, that local authorities are not allowed to act as a substitute or additional NHS for children. And just because the person's a child doesn't mean that the local authority is entitled to provide health services. So at the time, that meant that the only body that was able to provide the short breaks service to child D was the PCT, the Primary Care Trust, what would now be the Clinical Commissioning Group. So that was a child where the services that were needed fell entirely on the health side of the line. A really good point to make, I think, that local authorities cannot provide all the services that every disabled child needs. The other thing I was going to pick out in the national framework that's very important are these provisions here in relation to transition to adult services. So what's said here is that every child or young person with a package of continuing care who's approaching adulthood should have a multi-agency plan for an active transition process, adult or universal health services, or to NHS continuing health care. And the summary here that's really quite striking, at 14, the young person needs to be brought to the attention of CCG as likely to need an assessment for NHS continuing health care. 16 to 17 should do the screening under the NHS, under the continuing healthcare framework, and an agreement in principle that the young person has a primary health need, so that at 18 there can be full transition across to continuing healthcare. And that's in the guidance here. When the young person is in their 17th year, eligibility for continuing healthcare should be determined in principle by the relevant CCG. So very important that that process happens, because as it says in the guidance, once a young person reaches the age of 18, they are no longer eligible for continuing care for children. So there isn't, as we'll see under the Children Act scheme in a moment, these transition requirements that allows for services to continue in being provided by children's social care. There isn't the same opportunity for children's health services to carry on post 18 in relation to continuing care. They have to transition at 18 to the NHS continuing healthcare team. So where is that transition duty in relation to children's social care? Well, it's found most obviously in Section 66 of the Care Act. So we'll come on to the Care Act in more detail in a moment. But if we look at Section 66, we see that there's these provisions that are inserted into the Children Act and into the Chronically Sick and Disabled Persons Act, requiring continuity of services. And what that does is it requires local authorities to carry on providing children's social care to children who are receiving it until the adult social care process is concluded with either a non-eligible decision or a care and support plan in place and adult services being ready to go. So there's no cliff edge at 18 in relation to children's social care because of these rather complicated provisions inserted by Section 66. If we look at the Care Act more generally now, before I have a look at the questions, we see that unlike for children's social care, all the law on adult social care is actually now in one place in the Care Act and in the regulations made under it. And it starts, Section 1 of the Care Act, with a duty to promote individuals' well-being. So in anything that local authorities do in relation to the Care Act, they have to promote the individual's well-being, which includes all the relevant factors set out here in subsection 2, including their personal dignity, their control over day-to-day life, for example. So social care and adult social care is intended to be a holistic service promoting all the different areas of a person's life. And these are the things that local authorities must take into account in all their decision making. They're all the things you would expect, including the presumption, the importance of beginning with the assumption the individual is best placed to judge what will promote their well-being and their own views, wishes, feelings, and beliefs. That's the Section 1 duty. Another very important duty in relation to the Care Act is Section 5, which requires there to be an effective and efficient operation of a market in services for meeting care and support needs, so that people can choose from a variety of high quality providers. So local authorities aren't expected to actually provide any of their own adult social care services. They are required to commission services from the market in a way that results in people having high quality and choice of provision. So then the question is, how do we get into the adult social care arena? And the answer is that if you are in children's social care, you should have a transition assessment. So between sections 58 to 66, the Act sets out the process of transition from children to adult social care. And in particular, there's this child's needs assessment, which should really be called a transition needs assessment, would be rather more helpful. So between the age of 16 and 18, the adult social care team must do an assessment to identify whether the child is likely to have needs for care and support after becoming 18, and if so, what they are. And that then forms the basis of their first Care Act assessment, and a care and support plan can be put in place ready to go on the young person's 18th birthday, if that's appropriate. And there are equivalent provisions here in relation to parent carers and young carers as well. So the answer is there should be a transition needs assessment carried out at some point after the young person turns 16, but well before their 18th birthday. If you're a new entrant to adult social care, so say you've had an EHC plan that named a special school and you didn't need any social care services as a child, you're leaving school, you're going to need social care support as an adult, then you will come in through an adult assessment. And we see under Section 9 of the Act, where it appears to a local authority that an adult may have needs for care and support, the authority must assess whether they do and what they are. So all that you need to get an adult social care assessment is the appearance of need, some level of need. It's a very low threshold indeed. So it's almost an on-request duty, and the same applies under Section 10 for carers of adults as well. So it's very straightforward. It should be very straightforward to get yourself assessed as a disabled adult. And then the question is, well, do I have eligible needs? And we see under Section 13 that where a local authority identifies any needs, it must determine whether any of the needs meet the eligibility criteria that are set out in subsection 7. And that says that they meet the eligibility criteria if they meet the regulations, meet the tests and the regulations. And the regulations for eligibility are care and support eligibility criteria regulations. That'll be the one. I think it's 2015. Let's see. Yeah, there they are. So what I'll do is I'll put that link in the chat as well. This is potentially very important if you are concerned about eligibility for adult social care. What we see in the regulations is a definition of what eligible needs are. So an adult's needs meet the eligibility criteria if they arise from or are related to a physical or mental impairment or illness. Well, again, that's probably not too difficult to show. As a result of their needs, the adult is unable to achieve 2 or more of the specified outcomes. Now that sounds difficult, but we need to look down here in sub-regulation 3, because being unable to achieve an outcome is defined as including if you're unable to do it without assistance, or if you're unable to achieve it without, if you are able to do it without assistance, but it causes you significant pain, distress, or anxiety, or you can do it without assistance, but it puts someone's health or safety at risk, or even if you can do it without assistance, but it takes you significantly longer. So actually that test of inability, of being unable to do something, is really not a very helpful form of words, I suggest. A better form of words might be finds difficult. But we see how the test is then defined here in regulation 3, subregulation 3. So you have to be able to show, as a result of your needs, you cannot achieve without difficulty 2 or more of these outcomes here. And we can see what they are: maintaining nutrition, personal hygiene, toileting, ranging up to things like engaging in work or training, or carrying out caring responsibilities for a child. So very broad set of different outcomes, again, adults would normally expect to be able to do. And the third part of the test then is that as a consequence of all of this, there is or is likely to be a significant impact on your well-being as defined in section 1. And significant just means more than minor or trivial. So it's not a particularly high test to get across. So very often for our disabled young people, once they've had their assessment, it will be satisfied that the eligibility criteria are met. So then what happens? Well, the core duty in the Care Act is here in section 18. It's the duty to meet needs for care and support, and it works completely differently to the Chronically Sick and Disabled Persons Act. We've seen how the CSDPA for children defines a list of potential services and says, is it necessary for us as a local authority to provide any of them? Whereas here, the duty is simply to meet needs. So a local authority, having made an eligibility determination, must meet the adult's needs for care and support, which meet the eligibility criteria, as long as these technical requirements are satisfied. And then we look in section 8 of the Act, because that's headed how to meet needs. And we see that all that does is give examples of what may be provided to meet needs under section 18, amongst other provisions. So accommodation in a care home or otherwise, care and support at home or in the community, counselling, other types of social work, goods and facilities, information, advice and advocacy. They're all examples of ways in which needs can be met. So there's no fixed requirement to provide services of any particular form at all. And that's good in the sense that it promotes flexibility, but it does make it much harder for disabled adults and or families to enforce a particular kind of provision that they may want. Having said that, it's very likely that if you want a direct payment, you will get one. So there is a statutory test here. Let's assume that the disabled person has capacity to request it themselves. We see there are 4 conditions that then have to be satisfied for them to get a direct payment in order to buy their own care. The final condition is that the local authority is satisfied that making the direct payments to the adult or a nominated person is an appropriate way to meet the needs in question. And the local authority may say, well, we're not satisfied with that, but it's very rare in my experience that happens. So most of the time, if you want a direct payment as an adult, you can have one. How then what's then the process of identifying how your needs are going to be met? We've got these duties here that are described as the next steps duties. And in section 24, we see that where a local authority is required to meet needs under section 18, or decides to do so under the powers to meet need, it must prepare a care and support plan for the disabled person or a support plan for the adult, which will be the carer. Tell them which, if any, of the needs may be met by direct payments, and then help them with deciding how to have their needs met. So the short answer is it's the care and support planning process that is the really important process under the Care Act in terms of identifying what services you're actually going to get. We see here what's required to be in a care and support plan is set out in section 25 of the Act. One very important innovation in the Care Act is there is now, for the first time, a duty to meet carers' needs. So any carer of a disabled adult, having had their own assessment, if their eligibility criteria are met, which is similar to what we've seen for adults, but disabled people themselves, then the local authority must meet their needs too. So that's a really important change in the law to give not just parent carers, any carer of a disabled adult, an actual legal entitlement to services. So a few other points to pick out before I look at what the questions are. Looked at the next steps, duties, direct payments, and so on. Continuity of care when people will move. Unfortunately, that's not a particularly powerful entitlement because the receiving local authority, of course, can always reassess. Safeguarding. So for the first time, we had statutory duties in relation to disabled adults who are at risk of abuse or neglect, and section 42 of the Care Act imposes an inquiry duty. So where a local authority has reasonable cause to suspect that an adult in its area has needs for care and support, is experiencing or is at risk of abuse or neglect, and as a result is unable to protect themselves, then they must make inquiries, obviously decide what to do. What can they do? Well, they could provide services or offer to provide services under this Act. They could make an application to the Court of Protection if they think the person lacks capacity for some kind of order or declaration that will protect them. And if they have capacity but they're still vulnerable, there's the inherent jurisdiction of the High Court, which can be used, but only in very exceptional cases to provide protection. Or they can call the police if they think that a crime has been committed. Those are really, as far as I can see, the three options that are open to a local authority that has safeguarding concerns as a result of an inquiry under Section 42. There's then also, as we've seen the transition provision, requirements in relation to advocacy. So a disabled person, or indeed a carer, who is struggling to engage with any of the processes under the Act and would experience substantial difficulty in engaging, is entitled to have an advocate appointed for them. But if there is a person who's willing and able to do that, see here under subsection 5, then there is no duty to appoint an advocate. So very often parents may wish to do that and should be supported to play that role. If they're not willing or able to do so, or it's not appropriate for them to do so, which would need to be evidenced, then the local authority should appoint an independent advocate instead. So those are the key provisions of the Care Act that I wanted to tour people through quickly. Oh, just one more, it's quite important. Under Section 73 of the Care Act, private providers of adult social care are treated as public bodies and are required to respect people's human rights. And my view is that the effect of that is that the same applies for children's providers of social care and also health providers to disabled people as well. So that is very important additional protection that means that people can bring human rights claims against bodies that would otherwise be able to say, well, we're not public bodies, we're not required to respect people's human rights, because Section 6 of the Human Rights Act only applies to public bodies. So I'll have a look at the Q&A now and see if there are any questions that need to be picked up. What advocacy is there for parent carers? Well, as I say, we're looking, I'm afraid, at the English scheme here. The Welsh scheme is different. So the question is specific to Wales. But there is a requirement for parent carers to have advocates if they themselves are experiencing substantial difficulty in engaging in the processes under the Care Act. Can a paid carer be the advocate as well? Yes, they could be, but it would be inappropriate, I think, if you look at how the advocacy duty works under subsection 5 here. They can't be a replacement for an advocate because they're involved in providing care for remuneration. So they can't not be the advocate, and they wouldn't be an independent person in terms of the independent advocacy duty. So in fact, probably the answer to that is no. Is there an obligation to provide residential accommodation under the Care Act? Well, as we've seen, residential accommodation is one of the types of provision that can be made under the Care Act. It's the first type that's listed in Section 8, but there's no absolute duty to provide anything under the Care Act. The duty is to meet needs. If a carer is an advocate with a power of attorney being needed, okay, that opens up a whole can of worms that I need to delve into now, if you'll forgive the metaphor, which is in relation to mental capacity and decision making for people who lack capacity to make decisions for themselves. So let's look briefly. Of course, the Mental Capacity Act would require a talk of its own, but let's look briefly at how that works. So under the Mental Capacity Act, we see that in Section 2, there's a definition of how a person may lack capacity to make decisions for themselves if at a material time they're unable to make the decision for themselves in relation to the matter because of an impairment of or disturbance in the functioning of the mind or brain. And then people may be aware that under Section 3, you're unable to make a decision for yourself if you're unable to do any of these 4 things: understand the relevant information, retain it, use or weigh it, which is often very important in disabled young people's cases, or communicate it. So if you, as a disabled adult, can't make your own decisions, well, what happens then? Well, decisions are made in your best interests under Section 4, where you have to take into account all the circumstances and give very significant weight to the person's own views. And the vast majority of such decisions are made, so I don't need 4A, that's my declaration of liberty. Under Section 5, which allows people to do acts in connection with the care or treatment of people with lack capacity, as long as they reasonably believe the person lacks capacity and that it's in their best interest. So the vast majority of such decisions are made informally. Now, if the person has capacity, but potentially loses it or may lose it in the future, they can make a power of attorney. So we can all give away our decision-making rights to others, our loved ones, in the future. But for the vast majority of disabled young people, they can't grant power of attorney because they don't have capacity in the first place, the group we're talking about. And in that situation, we're looking at a different concept, which is the concept of deputyship, welfare deputyship. And as the name suggests, that person is then the deputy of the court of protection, making decisions that the court would otherwise make. It's relatively straightforward to get deputyship in relation to property and affairs, managing people's finances, if they have any. It's much harder to get deputyship in relation to personal welfare decisions. And if you're considering applying for personal welfare deputyship, I would suggest making sure that you get advice. Okay, a few other questions. If accommodation and meals were funded through an EHC planning college, must this be continued at university through social care? And the answer to that is potentially. So there would have to be an assessment under the Care Act, and a decision would need to be made if that was a necessary and appropriate way to meet the young person's needs. So it would all depend on the outcome of the assessment process. What might carer support look like under the Care Act? Would it be respite, or would they expect other family members to provide this? Well, again, there is no defined set of services. It could look like whatever is appropriate to meet the needs. The local authority can't expect family members to provide anything for adults. They can ask if family members are willing and able to provide things, but there's no legal requirement to provide care for adults, including our own adult children. And so it has to be a conversation about what the family are willing and able to do. Any guidance on separating the needs of the carer from the needs of the individual? Brilliant question, but that's more of a social work practice question than a legal question. The law says you must do that. You must identify the individual needs, but you must also take into account each other's needs in the assessment process. So that's really a question to direct to a social worker, I'm afraid, rather than to a lawyer. Are there rights of appeal against local authority decisions? No. So the Care Act doesn't have yet, at least, its own tribunal process. The only appeal right, therefore, would be within an EHC plan in terms of trying to trigger a recommendation from the tribunal. So again, your options are either a complaint under the Care Act complaints process or a judicial review if it's a sufficiently significant and urgent dispute, and particularly if it looks like there's some kind of dispute about the law here. I'm holding on to all the health questions, so I'm going to come there. Do parents get financial support to provide care? Well, no, they don't, apart from through carers allowance, which people will be aware is a very modest sum, shall we say. It would be open to a local authority to provide additional funding because they can meet needs in whatever way they think is appropriate. But generally, they won't do so, in my experience. They might make a direct payment in terms of providing services to the disabled person. And direct payments can be used to fund family members, including close family members, but only where quite a high test is met in terms of it being necessary for the person's own needs. The local government and social care ombudsman, yes, absolutely. So the complaints process for the Care Act, same as for children's social care, goes through the internal local authority stages and then goes on to the ombudsman. So the ombudsman is there as the final part of the complaints process. Does the carer have to undergo a financial assessment as well as the cared for person? If the carer is asking for any services, then potentially yes. Now, again, not every local authority charges for services for carers, but some do, and financial assessment is relevant. What should be happening during the support planning process, and what should be included as part of a support plan? So the thing we haven't looked at yet, which is very important, is the Care and Support Statutory Guidance. So let's go there. You'll see, I hope, that in every area there's going to be an act. There's then going to almost certainly be some regulations that flesh out the detail, and then there'll be guidance, lots and lots of guidance, of course. And here is the Care Act guidance as updated in January of this year. And so, for example, there is this chapter here on person-centered planning and care and support. And so rather than try and answer that question now, I'm just going to refer you to the guidance, because that's going to give you a much better answer than I can give in the few minutes that are available now as to what must be involved. Question: the care and support plan, could this be locally called the Care Act assessment? No, the assessment has to be a different thing. The assessment is the process of determining whether or not you have eligible needs. The care and support plan is then the process of deciding how those eligible needs should be met. And it's very important that those things are done separately and in stages, and there's a clear decision about what the needs are and which are eligible, and then a stage where we do care and support planning to work out how to meet those needs. Not always the case that that process is as clearly separated as it should be. What about a situation where there's no suitable services in the area to meet needs? What does the local authority have to do then? Well, it has to meet the needs. So it either has to set something up, commission somebody else to set up a service, provide a direct payment if the person and family want that, fund a service outside the local area. There's lots of different ways it can do it, but the duty at the end of the day is to meet the person's needs. And so in terms of understanding whether the local authority are complying with the law here, we can ask a very straightforward question, which is, are the person's needs being met? If there are unmet eligible needs, then the local authority is acting unlawfully. Questions about savings and disability-related expenditure are probably too technical for me to go into now. The Care and Support Statutory Guidance has annexes that are specific on charging, which are very important. And we see there's an annex on the treatment of people's capital and an annex on the treatment of people's income. So if you've got concerns about the financial assessment and charging process, I would suggest looking through those. And again, where there's a dispute, you'll need to take advice. The principle, of course, is that adult social care is generally a charged for service. And so wherever a person is getting support under the Care Act, certainly disabled people themselves, it's very likely they'll be expected to pay a contribution to that, or their direct payment will be reduced to reflect what it's said that they should be able to pay. There are some fundamental points, like the fact that there's a minimum income guarantee, which is the level of income support plus 25%, and that people's disability-related expenditure needs to be taken away from the charge. But exactly how the particular charge is calculated is going to be very complicated in many cases, and what capital and income is disregarded is set out here in Annex B and C. Can a local authority refuse to carry out a transition assessment if social services are involved? I don't really understand that question, because it's where social services are involved that a transition assessment has to be carried out. But the short answer is no, that wouldn't be a basis for refusing a transition assessment. Lots of questions that are coming in about continuing care. A question about children's continuing care. Well, how would a parent carer ask for that? Never been told about this. So different local areas have different processes. So you should look up in your local area what the continuing care process is, and then ask around. So the GP would be a sensible person to ask, any social worker that's involved in the child. It's supposed to be a joint arrangement between the local authority and the CCG. And many local areas have a designated lead for children's continuing care, and their details should be available on the internet. Coming on to adult eligibility for continuing healthcare shortly. Who can request a CHC assessment? Anyone can, although some local areas seem to have policies that are rather different to that. Transport, so that's quite an interesting point. There is a duty, as we've seen in the CSDPA, to provide transport to social care events. Under the Care Act, of course, there's no specific duty to provide any kind of service, but if it's necessary to get the person to the service, it may well be necessary to provide transport for them as well. So that may well be a service that is necessary and appropriate under the Care Act. Where direct payments are made, can the local authority recover funds that are unused? In short, the answer is yes, they can. And families need to be quite careful, I think, in terms of assuming, for example, that they're entitled to build up a backlog of direct payments and then use them for the person's best interest. They're not. And it'd be very important to check in every case what the direct payment agreement says, because before the money starts to move, there should be a written agreement that everyone signs up to understand how that money is supposed to be used. Is it a sufficient assessment of need to simply list the child's diagnosis and nothing else? Well, absolutely not. No, that's not an assessment of need. That's a description of the child's diagnosis. Oh, a very important question about young disabled people who want to go to university. Now, of course, we know that EHC plans don't cover university. So there's additional needs may well fall to be met under the Care Act in terms of social care support. There's also, of course, some support for disabled young people in university, disabled students allowance, so on, although those have been reduced. And the university itself will have reasonable adjustments duties under the Equality Act and other duties under the Equality Act, which I talked about in the schools context in the first of our webinars. So, but yes, the Care Act will definitely be an important part of the mix there. Removing some questions that are too specific for me to answer now. Okay, so I think that's probably a good, there's one other question I missed earlier that I wanted to answer. What about, how do you use an independent assessment, which could be for a child or an adult, of course, perhaps from an independent social worker? The answer is that would then become a relevant consideration that the local authority would have to take into account. They don't necessarily have to do what that person says, of course, but they do have to take account of all the relevant information. And that would include any independent assessment that's been obtained. So before I go back to the questions and see if there's any more that have come in, I'm going to just complete the picture by looking at adult continuing healthcare. So now we have the national framework. And this is statutory. Unlike the children's framework, this is actually issued under regulations, and it's also 3 times as long. See, it's 167 pages long. So it's a much more detailed and complex piece of guidance. And it was revised more recently as well in 2018. But it works in a very similar way, I'd suggest. So there's nothing radically different about the 2 sets of processes. We see that an individual is eligible for NHS continuing healthcare if they have a primary health need. This is a concept developed by the Secretary of State to assist in determining when the NHS is responsible for providing for all of the individual's assessed health and associated social care needs. So what is different for adults is that the guidance is much clearer that where a person's eligible for continuing healthcare, it's the NHS that meets all of their assessed health and associated social care needs. So there'll be no role for the local authority adult social care team at all. We see the definitions here. NHS continuing healthcare is a package of ongoing care arranged and funded solely by the NHS, where the individual has been assessed and found to have a primary health need. See what the CCG currently is responsible for. That will all change potentially under the new bill, of course. And local authorities are responsible for referrals. So where it appears the person may be eligible for NHS continuing healthcare, the local authority must refer the individual to the relevant CCG. So it's expected that the referral will come from the local authority. So a summary of the key legislation may be of some relevance. Generally, it's Section 3 of the NHS Act that requires CCGs to provide services. And here's the Section 222, which limits the services that local authorities can provide, because they may not meet needs under Section 8220 by providing anything that would amount to a health service. So that's why primary health needs trump anything that would be normally provided by social care. And here's this definition of what a primary health need is. And in particular, you look at four things. You look at the nature of the need, the intensity, the complexity, and the unpredictability. So needs, it's not that a certain type of need is always health or care. It's about how intense essentially that need is that will push it across the line to becoming a primary health need. You're not allowed to make decisions on eligibility based on diagnosis, setting, anything else. It's always got to be based on an assessment of needs. There's also in this document very detailed guidance on the transition process from children's to adult services. Of course, because this is statutory guidance, it's even more important. And we see, again, this requirement for there to be proper transition planning from the age of 14. The formal referral for screening when they're 16. And as soon as practicable after their 17th birthday, eligibility should be determined in principle, so that where applicable, effective packages of care can be commissioned in time for the individual's 18th birthday. So that's the obligation on CCGs to make sure that transition to adult continuing healthcare is well planned. Right, I'll jump back to the questions and see what we've got there now. So what can a personal health budget for adult continuing healthcare funding include? Anything, essentially. There's no fixed list of services that would fall within that concept. What they do have, though, is some guidance on personal health. So as with social care, people like to move towards money as a way in which everybody's can meet needs. I'm trying to find, there is some statutory guidance on personal health budgets. It'll probably be somewhere in here. I'll put the link in here and people can have a look themselves if they're interested, rather than me trying to find it. Now, can you ask for transition assessment at 14 to 16 even if there's no EHC plan? Absolutely. So that's the whole point I think I was trying to make in this talk, and the way we've divided the talk, saying there's EHC plans and then there's the health and social care scheme, which really is very separate to the EHC plan process. So there's no issue there at all. Great question. What's the practical impact of getting funding under CHC as opposed to the local authority? Well, I'd say there's at least two, possibly three differences. The first and most obvious in relation to adults is that adult social care will be charged for, whereas NHS services are free. So having a primary health need and being eligible for NHS continuing care can be massively advantageous for disabled adults. The second is that the NHS, despite no doubt very significant constraints, still has significantly more money than local authorities. So it may be that you get a more generous package, and there's an expectation that continuing healthcare packages will be more substantial because they are reserved for people with the most complex needs. The third difference you might experience is, of course, the NHS is used to providing medical type services. And so it may be that the package that's put forward is rather more clinical or perhaps more traditional than from local authorities. But I would emphasize and underline 3 times the word may there. There are no doubt some very progressive CCGs. There's no reason why a continuing healthcare package should be any different necessarily to an adult social care package, or certainly no reason why it should be any less innovative or less flexible. But in my experience, there are some CCGs certainly that tend, for example, to want to favour residential care or nursing home care, as opposed to other ways in which needs can be met. So what are the requirements on health bodies to assess needs? Well, it's less straightforward than it is in relation to local authorities, because there are various requirements in certain situations, such as part of the EHC Needs Assessment process, or if someone is said to be eligible for continuing care. But there isn't a freestanding assessment duty like there is under Section 17 of the Children Act in relation to health, because it will all depend on which kind of health service is said is needed, and whether that can be a universal or a targeted service. If it's going to be a very significant level of health input, then there will be an assessment duty under the children's continuing care or the adult CHC framework, and or in relation to an EHC plan. Can a local authority refuse to meet health needs before the NHS deems they're in fact primary health needs? Great question. Yes, it can, because actually they can't provide health services. So if, for example, you went to your local authority and said, I want 24/7 nursing care, regardless of what decision making the NHS may have made, the local authority is going to refuse to provide that, say it's unlawful. But they should be very careful before refusing to meet needs that are where the service is less obviously a health service, and leaving people to fall in a gap if the NHS haven't yet decided that they are going to be health needs that are met. There should be a question about 3-month reviews, and I'm afraid that it's rather a technical question, and again I'm going to refer to the guidance for the answer to that. Should speech and language therapy and sensory OT be part of a CHC package? Another great question. The answer is, well, yes, it could well be, but of course if the young person has an EHC plan, we know that those therapy services will almost always be special educational provision, because they have the effect of educating or training the child or young person. So they will go in section F of the plan. They'll be the local authority's responsibility to secure. But if there is no EHC plan, then yes, there will be health services, that could well be the kind of thing that a child or young person who's eligible for continuing care or CHC should receive under that planning process. Why won't children's social care do an assessment for my 9-year-old son? Well, I'm afraid that's far too specific for me to answer now. Save that. Given what I've said on the talk so far, I would suggest that anyone who has been refused an assessment may well want to get case-specific legal advice. And as well as the solicitors' firms on my blog, there are, of course, very important support offered by the CENDIAS services in terms of information, advice and support. And there are a range of charities operating in the area like EHC and SOS SEN, although they do tend to be more on the education side than in terms of social care and health. Can you qualify for adult continuing healthcare and also have an EHC plan? Absolutely. Of course you can, because they're two different things. The EHC plan will be ensuring primarily that your educational needs are met. Your adult CHC plan will be ensuring that your health and care needs are met. And so if children or young people are not in school but need speech and language therapy or occupational therapy, of course they can have that under an EHC plan as provision otherwise than in school. But if they're not eligible for an EHC plan, then that will have to be a health service, which is requested. And I would suggest probably is requested through the continuing care or the continuing healthcare service. But it's not the case, of course, that if you're not eligible for continuing care or continuing healthcare, you can't get any therapies. But then you'll be probably on a waiting list looking for the CCG to exercise its general obligations to commission services. A very interesting question. As a parent carer of a 19-year-old, can one, I'll generalize it, refuse to help? Yes, you can. We abolished the liable relative rule in this country a long time ago. There is no legal obligation on anyone to provide anything for an adult, although of course we all feel moral obligations to provide and support our family. It's not a legal obligation. There's a legal obligation to care for children, of course, because otherwise the local authority will take care proceedings if you're not exercising, you're not fulfilling your parental responsibility. But parental responsibility ends at 18. And so there is a very important discussion that needs to be had by families and local authorities about what the family are willing and able to continue to do. And the local authority can't assume that, for example, evening care will be provided by relatives. It has to be a genuine discussion and dialogue at that stage, in a way perhaps that it isn't so required to be for children. So what about where a local authority has a duty to meet needs but isn't doing so? How do you remind them about the law? Well, you can certainly remind them about the law by using the book, using this talk to write to them, email them, tell them they're not doing what they're supposed to do. But at the end of the day, if that isn't working, you're going to need to get legal advice. Now, a question about ordinary residence. And ordinary residence is very difficult at the moment because of the implications of the judgment involving Cornwall County Council. And again, I think on that, I'm just going to say that if there's any argument about which local authority is responsible, it will be necessary to get case-specific advice because that situation is so fluid at the moment. How can you make a complaint about adult social care if you don't have welfare deputyship? The disabled person should be able to make a complaint using any advocate or supporter. So I'm not aware of there being any requirement for you to be a welfare deputy in order to trigger the complaints process. And if that was the case, then we'd need to have thousands and thousands more welfare deputies than we do at the moment. So that simply can't be right, basically. Can a local authority refuse to make a direct payment and say the family is financially responsible after 18? Well, no, I think, again, we've been clear that family members are not responsible once a person's turned 18. So it's that kind of situation where people, again, are going to need to get advice. Does the equity in your home count towards a financial assessment for carer services? Potentially, yes. Again, on charging questions, I'm going to direct people to the annex to the guidance and say that if you need case-specific advice, you should definitely get it. So how do you get speech and language therapy, occupational therapy, and physiotherapy post-18? Well, if you are eligible for continuing healthcare, then yes, that would be an excellent way to do it. Otherwise, it's going to be very difficult to get it from the local authority because those are health services as opposed to social care services. So although the local authority has to secure those services through its education duties when there's an EHC plan in place, otherwise, it seems to me it's very likely that it's going to be a matter for you to argue out with the local NHS as opposed to the local authority. If you've got a local authority assessment of need, but then there's a decision that the person's eligible for continuing healthcare, does the NHS have to meet those needs? No, not in exactly the same way, but they will have to meet all the needs, including what would normally be seen as social care needs. And this is sometimes people get confused, and there's a suggestion that the NHS will only be meeting the health elements. And no, it's very clear. We've seen it already in the national framework. If you're eligible for continuing healthcare, the NHS takes over responsibility for all of your health and care needs. And one would assume the starting point for that would then be, in terms of social needs, the local authority's assessment, but they're not bound by it. So they could potentially identify needs in a different way. Is continuing care an appropriate pathway to meet needs if the needs would be met by services locally, but aren't because they're none available? No, the threshold for continuing care has to be based on the assessment of the individual's needs, not on the availability of local services, I'm afraid. If there's a negative decision on eligibility for continuing healthcare, what documents do you reference? Well, you look at the national framework, and the question is it the decision support tool? Again, to be clear, the decision support tool is an important part of the decision-making process, but it cannot be the answer itself. It indicates whether the person is eligible or not if they have certain levels of need, but that's all it's allowed to be, is an indication. Just looking through again. An interesting question about the idea of a mass judicial review for over 50 families. Can we bring a class action? So we don't really have that concept of class actions in this country. It's an American concept. There are provisions for representative actions to be taken, but it's very difficult to do that in a public law case, in a judicial review case. What tends to happen instead is that, say there was a policy that affects lots and lots of people, a number of those people, perhaps 3 or 4, will instruct solicitors to bring a claim, get legal aid, and then the other affected people can put in witness statements to explain the impact on them. And assuming that their interests are the same, that will be an effective way to make sure that that the issue is challenged. But it is important to be careful there, because strictly speaking, the remedy the court gives will only be for those people who have actually brought the claim. So, you know, in that situation, I'd want to be one of the 4 claimants. But it's very unusual in these kinds of areas to have class actions or group litigation, as is known. An easy question: is a child and family assessment the same as a child and need assessment? Yes. So local authorities will often refer to a child and family assessment as being one type of child and need assessment, but you should be able to clarify that with your local authority. What should families be doing in advance as their young person is moving towards 18? That's an excellent question. So I would say a number of things need to be ensured. First of all, if there's an EHC plan, is it going to continue? And that very much depends on whether the outcomes have been achieved or not. Is the child getting social care input from children's services? If so, there has to be a transition assessment moving on towards adult social care. Is it a case where there might be eligibility for continuing healthcare, in which case we need to trigger the transition process for continuing healthcare? And in terms of capacity, well worth thinking about applying for financial deputyship, property and affairs deputyship. May not be appropriate to go for personal welfare deputyship, because there has to be, in short, a good reason why the court should give you that power, as opposed to allowing everyone to make best interest decisions together and refer disputes to the Court of Protection. So those are the kind of checklist questions, and again, individual case-specific advice being needed. An interesting question earlier on about access points to social care, particularly children, but I think it applies to adults as well. And what happens if you go in through safeguarding? It is really important, I think, that local authorities have to distinguish between a child in need case and a child at risk case. And if families are pushed down a safeguarding route inappropriately, they should object to that, and if necessary, seek individual legal advice. A really interesting question about autism and the idea that autism may well be removed from the scope of the Mental Health Act. That's something that may happen under the new legislation that's being put forward to amend the Mental Health Act. But there's no issue with, in terms of the social care and health entitlements more generally, that autism is a disability as it's defined in the various pieces of legislation, and services will need to be provided as necessary to meet the needs of autistic people. Last couple of minutes, just going back down to the bottom, see if there's anything else. Isn't deputyship expensive? Well, it can be, if certainly to get legal advice to make the application for welfare deputyship is likely to involve a cost. But many people can apply for property and affairs deputyship themselves without needing to engage lawyers to assist with that. If you've had an assessment but then nothing's ever been done, what can you do other than complain? Well, that is the situation. You either make a complaint or you need to seek legal advice about the potential for a judicial review. And I would strongly suggest that if you're being seriously impacted, or the young person is being seriously impacted by not getting support post-assessment, that's a time where it's highly appropriate to get legal advice. Oh, a very interesting question about caps on hourly rates for direct payments. Almost certainly unlawful in my view, because the direct payments is only going to be a way of meeting needs. And if the needs can't be met for £11.50 an hour, then the local authority will have to pay more. Obviously, if the needs can be met within the capped rate, then all well and good, as long as they're met appropriately. There's no obligation to fund the particular service that someone desires. But if the person has a need that is only able to be met appropriately at a greater cost, then the direct payment will have to be increased. Very difficult for local authorities to justify caps of that sort, I would suggest. Good. Well, thank you ever so much, everyone, for all the questions. And I'm sorry that I haven't been able to answer every single one, but I have answered 137. So I think that's pretty good going. It's been excellent discussion with you all. I'm sorry it couldn't be face-to-face, but at least through the screen like this. I hope it's been a useful talk for everybody. And do please join us for the fourth and final part of this series, where we're going to be looking at what might be coming next through the SEND Green Paper. With that, I'll hand back to Sharon.